Now, distinguished delegates, I would like to say a few words. We have had a productive 10th session of the Assembly, and despite having to work on a very compressed schedule due to the unexpectedly long elections, we have indeed elected 6 judges to the court, as well as 6 members of the Committee on Budget and Finance, and of course, we have elected the new prosecutor. Working late into the nights and evenings, we were able to find agreement on an omnibus resolution on the budget, both of which have just been adopted by consensus. I am aware that the budget that we have just adopted is not a perfect one and does not represent the best case scenario for any of the stakeholders involved. I therefore thank state parties for their flexibility in finding a consensus under these difficult conditions, and the court for making painful cuts. I nevertheless think that the totality of our achievements is justifiable cause for a bit of pride among states parties. This Assembly has also given us cause for election on a number of areas. Most immediately, the conduct of business at the sessions of the Assemblies warrants a review. The correct balance must be struck between the time taken up by necessary and by substantive discussions, especially in view of constraints posed by the availability of interpretation. The discussions these few days have also demonstrated that the entirety of the budget process deserves very close scrutiny. There is no lack of ideas as to how this must be done, and I will seek to use the next year to consult widely and transparently with all involved stakeholders, but most especially with states parties, in order to present concrete proposals for adoption at the next session of the Assembly. I will begin these consultations, which I hope to conduct in both sides of the Atlantic immediately upon the end of the winter holidays. I was heartened to hear expressions of support for the core states parties who took the floor during the general debate. Indeed, even during the tough budget negotiations, both sides underscored their deep commitment to the work of the court. Our challenge now is to operationalize this political support when the court most needs it, in preventing non-cooperation and in defending it from those who unfairly criticize it. The coming year also brings with it the opportunity to take forward work on complementarity. If we have learned anything from these budget discussions, it is that the court is not in a position to rapidly expand its docket, either by expanding prosecutions beyond those most responsible or by opening investigations in many more situations. Therefore, the only way to prevent the emergence of an impunity gap is to do states to prosecute the most serious crimes under international law within their national jurisdictions. The Assembly and its Secretariat have a role to play in furthering the cause of complementarity, and I hope that after 2 successful retreats and several informative side events at this Assembly, the next year will bring with it concrete first steps towards the implementation of the Kampala mandate. I have been informed that the focal points also wish to convene discussions on these topics on both sides of the Atlantic. I now also would like to thank the 2 vice presidents of this that have been elected during this Assembly, by Ambassador Markus Borlin and Ambassador Ken Kanda, who have provided me with support and assistance. And of course, I am also grateful to other members of the Bureau for their advice and support. Now it is a special privilege to me to commend Judge Song for his tireless efforts and also to wish him happy birthday. which is today. Judge Song has also encouraging ratifications of new states parties, in particular within the Asia-Pacific region. And we wholeheartedly welcome his work also in drawing the attention to the principle of complementarity and to all the efforts that need to be undertaken in this respect. I would also like to say of this session about the first prosecutor of the International Criminal Court, Mr. Luis Moreno Ocampo, for whom this will have been his last session of the Assembly as he prepares to leave office at the end in next spring. When he was elected by states parties to the Rome Statute in 2003, the court was a very different institution. There was no building, only the bare skeleton staff. The Rome Statute was still a novel instrument, enjoying the support of only half the states parties today and facing active opposition from several major actors in the international relations. During his term of office to date, Prosecutor Ocampo significantly contributed to the establishment of the court as the primary tool of the international community to investigate the worst crimes under international law. Now, 8.5 years after he has taken office, his office has become seized of cases in every way foreseen in Rome Statute, including through the referral of states parties, through a proprio motu application, and through a referral by the United Nations Security Council. It is especially noteworthy that the latest referral by the Security Council was done by an affirmative vote of all states parties. The prosecutor, more than any other single individual, sets the direction the court will take in deciding whether or not to open investigations, whether or not to seek indictments against certain people, and how to proceed. He invariably comes under tremendous political pressure from all sides. While it is natural that not everyone would agree with those decisions, I think it is clear that nobody would contest that they have been taken in an entirely independent manner, focusing on the facts and the law and leaving political considerations aside. I have been overwhelmed this week with the outpouring of support for Prosecutor Ocampo among member states. It is clear to me that this work is deeply appreciated among those present in this room today. On behalf of all states parties, I would like to wish him all the best of luck during his final months in office. Thank you very much.